We have Rocky Ravinder Gupta sir with us. Sir, as you know, sir is an insolvency professional. Sir is an advocate, and sir is also a member of INSOL. Today we have gathered to discuss on a very important topic. It's about the the notice sent by Ministry of Corporate Affairs, and it is about the proposed changes in IBC. There are still some stumbling blocks which are probably not allowing the IBC process to have its own pace. On that, some changes have been recommended, and those have come forward through the recommendations made by the Insolvency Law Committee and various stakeholders consultation coming forth. So they're broadly, rather, I would straight away request sir to kindly take us through the recommendations which have been made, and then probably sir will also allow everyone to share their suggestions. So sir, can I request?
Thank you, Nitin. Good morning, everyone. I hope you're coming from different parts of India and you are not in Delhi, at least not in north part of India where it's very cold. Anyway, so today we are going to discuss the new recommendation that have been given by the Insolvency Law Committee. As you know that IBC was enacted in 2016, and it was enacted to ensure a time-bound resolution of insolvency, maximization of value of assets. These are the terms which normally everyone speaks about. Promotion of entrepreneurship, ensuring greater availability of credit. And the central government in 2017 brought in the Insolvency Law Committee, which has had almost 4 reports that they have given out. And in the last year, they have brought out certain amendments, a proposal to amend the IBC Act. And these proposals are very, very important in terms of fastening the process of CIRP. Can anyone,
So your video got freezed. Participants, as we can see that perhaps there's a network issue at sir's end, so I will request sir to change the network, and sir will be joining in just a second. Thank you.
And I'll just take you through the amendments. I'll just give you a brief profile of these amendments. That's one is the enabling a swift admission process. It's one of the major areas where even the Supreme Court in the initial stages of IBC had said that the 15 days time frame to admit a petition is not mandatory but directory. But that was not a decision which would have taken care of the spirit of insolvency, where the time is of essence. The second amendment pertains to streamlining of avoidable transaction and wrongful trading. Most of the judgments that are coming out is that once CIRP process stops, the applications for avoidable transactions cannot go forward because COC has been disbanded. The resolution professional has taken up some other assignment. His assignment has finished. So that was one of the areas where certain amendments were needed. Then the time period for approval of resolution plans. Approval by the adjudicating authority and not by COC. So many cases where it has taken almost a year, 2 years to approved the resolution plans, which actually has stopped maximization, rather decreased the value of assets. So this was very important amendment that needs to be made in the act. Then the closure of voluntary liquidation process. This is something which talks about when a company voluntarily comes into play into liquidation, wants to liquidate itself. However, during that process, if something crops up, like it gets a good contract and again wants to finish off this process, there is no provision as such. So they are bringing some sort of a provision on those lines, and there is one provision for IBC funds. Now this provision has not been used much, but it is going to be coming into play very soon as the personal insolvency comes into play, because most of the time small MSMEs which do not have an asset base would not be able to actually fund the restructuring or the liquidation process. So that fund can be a lot of help in those matters. So Nitin, hello, Nitin, can you hear me?
Yes, sir, I can hear you, sir.
So now let's open up the discussion for everyone to come in. I believe everyone can raise a hand, and Nitin can take his question and or the comment that they want to put forward in this.
Sure, sir, we can go that way also. Or specifically, if we take one by one the recommendations that have been made, and then the participants can make their suggestions. Participants, please bear with us. There's some, again, network issue, and sir is joining in a bit. Just give us 10 to 15 more seconds. Thank you. So sir is joining from his mobile phone itself. Just give us 10 to 15 more seconds. And in the meantime, if I can ask, I mean, if anybody would like to volunteer on the suggestions which have been incorporated in the MCA notice, and okay, sir is there.
Can you, Nitin? Can you just put on the screen the MCA notification?
Sure, I'll just put it, sir. So can you see it now?
Yeah. Can we go on to 1.1?
Okay, sir. Sir.
So the first proposed changes is regarding the enabling a swift admission process. So what they propose to do is bring in that 15 days, 14 days timeline for admission or rejection of such applications, and in case the application is not admitted, then the adjudicating authority would need to give some sort of reasons for why they have not admitted the application in that specific time frame. Then the second thing that would speed up the admission process is the functioning of the information utilities. So the concept of information utilities was to bring in all the financial information of debtors and creditors into one place, so that these information can help the judges and the presiding officers of the adjudicating authority to take a decision in a faster way. So that is also being taken care of by one of the amendments, proposed amendments to bring to the IBC Act. So the further it says that the 1.4, when we come to that and they are planning that information utility records are only to be used for admission process of the application under section 7, 9 or 10. I don't know whether that would be very useful, because I have not been very being used much by the financial institutions. So unless and until till the time they are completely online and everybody has access to them, probably some sort of amendment should be there, that other than information that is with the information utilities, other information can also be used for the purpose of admitting or rejecting an application under section 7, 9 and 10. So let's start comments on this specific proposal.
I have a suggestion on this.
Yes.
Besides section 7, record of default even for section 9 application should be accepted. I believe somewhere there is a proposal in this paragraph itself, which says even if IU record is not available, maybe through other means the application can proceed. So since the threshold limit is 1 crore rupees even for an OC case, I believe someone who is outstanding of 1 crore rupees has sufficient bandwidth and infrastructure to approach an IU, and somewhere the financial discipline has to begin. Another concern of record of default for IU was that the acceptance of payability and acceptance of default for an OC would be a difficult situation, since they are dependent upon their contracts, etc., on the person, on the corporate data. But however, if someone is not giving a confirmation, this is a red flag right in the beginning. So somewhere the discipline has to begin. That is my point of view. So we can even put a suggestion that even for 9 it may be accepted, so that the stress on judicial infrastructure would be reduced.
Yeah, that's a very good suggestion. So if Nitin, you can record this, that for the operational creditors, if their total debt is over 1 crore, probably they can also be included in the information utilities section. But I have my doubts on this. But we can always send the proposals to them and the comments to them.
Sure, sir.
Anyone else wants to give a comment on this specific proposal?
Hi, good morning. This is Bhumi,
Good morning.
insolvency professional. With respect to the suggestion made by the learned friend just now that the section 9 operational creditors also to be brought under IU, if there are disputes, basically it comes in front of the court. So by bringing it under IU, are we not trying to eliminate the dispute spot at all? If there's an existence of dispute, then at the IU stage itself, it has to get eliminated, which IU may not be competent to deal with it. In section 9 applications, that's the main problem, because section 8, we issue notice, and with respect to supply of services and I mean providing supplies and services, I have come across various disputes, and in many orders also we have seen the adjudicating authority has dismissed the application based on the existing dispute. Whereas if you allow the IU to accept a liability, then this dispute part may be overlooked, and some of the CDs may be penalized because of that. That's my view.
Yeah, this is CA Hema. Adding on to what both of my friends have discussed, I would like to say that usually in many of the cases, it is seen that the dispute angle comes only after the notice is issued. And until then, so, they can have certain parameters, incorporated within the IU, wherein if those parameters are met and the time period within which a dispute can be raised by the CD, if that expires, then surely that OC case can, a platform should be given for him to put it up in the IU.
I just want to add, this is Advocate Ankur. Basically, in all these applications, what the NCLT is seeing for the principle of natural justice to give the notice to the corporate debtors, and then the entire things happen. So which particularly drag the section 7 application for a number of time, because once this is a procedural part where once the notice is given, he will submit his reply, then certain additional affidavits and has to be submitted, and which is take a number of not only days per month to just going for a final arguments. So how to address these issues?
My take would is very different on section 7 applications. The Act only says two things need to be taken care of. One is a debt, and the other thing is a default. If there is a debt and there is a default, it doesn't matter if there's a dispute or not. And if both of the debt can be confirmed by IU or by any other means, and the default can be confirmed by any other means of a banking transaction or something, then the petition under section 7 needs to be admitted. The principles of natural justice for the person to reply on this should not be there. That's my personal view. I'm not. What I have seen with the world over, that these are the two things. If there's a default and there's a debt, the application needs to be admitted.
Mr. Gupta, that is the intention of the IBC and section 7. But if you see from the 2016-17 onwards, and that the court normally asks to issue the notices to the corporate debtors, their directors, and then all the these things delay happens. Even in the case of the personal guarantee, once there are two stages. Once the application is filed, the person is not coming, we have to submit the again delivery of the notices, affidavits, etc. And once the application is provisionally admitted, and when the RP submitted his report also, then again the notice has to be issued. So this is I think the NCLT and the courts in different judgments held that principle of natural justice demand that the other party is to be heard, and which is again contrary to the intention of the section 7 or what you are saying. If there is a debt and there is no dispute, application has to be admitted.
Sir, in section 7, I don't think there needs to be a dispute to be taken care of by the adjudicating authority. Moreover, our IBC code enacted in 2016, enacted in 2017, December 2016, is evolving. Initially, the 14 days period was told as directory by the Supreme Court, but now since the amendment is coming in, where again the 14 days time frame is being given for admission, so that means that our Act is evolving, our insolvency processes are evolving, the courts are evolving. We didn't have any sort of specific insolvency courts in India, but now even the judges are also evolving in terms of the use of CPC in insolvency. Earlier they were using CPC in a big way, but now the use of CPC is decreasing because insolvency is a specific code where CPC is not actually required.
Absolutely. So my only suggestion that when these amendments happen, then it can be specifically mentioned that where the already the things are with the information utility and there is a clear things, there should not be any question of issuing the notices and these things. So if that is specifically given under the code itself, then the NCLT or the courts have a little discretion unless until they challenge it, somebody challenge it.
I would not completely agree with that, but I would say yes. In today's time, service of a notice through electronic means is immediate. So if an application comes in, and most of the times when an application is filed on any section or any other court of India, the service of that application or a petition has to be served upon the opposite party or the respondent in any matter. Right, so he's already been served through electronic means, through postal means, so whatever means. So I don't think he has been served, so they put in the petition unless and until this service has been done. Right. So
Mr. Gupta, how it happens, once you serve the notice, then you have to file the affidavit of service with the NCLT also. And sometime if the notice is not served electric means and something, they will say that you served again or give a public notice. So these things
that is why I'm saying the use of CPC is not required in insolvency.
Absolutely, I totally agree with you, but these are the things which are not implemented in practice because
they would evolve over a period of time because we are only 5 years old. The IBC code is 5 years old. So it would evolve over a period of time.
It's just a suggestion and a practical problems which are being faced in Section 7 application particularly. And the other thing, how happen, it's more a practical thing. Even when the Section 7 application is filed, banks also give the time because they are also negotiating with the parties. So they also try to get it delayed, and both the corporate debtor and the bank, sometimes this is also happen. This is a practical situation.
You're 100% correct on this, but like I said, time is of essence in any insolvency proceedings anywhere in the world. So these things need to be taken care of by the presiding officer of adjudicating authorities. That I mean, you don't need a month's time. You can have a couple of days time to have a negotiation with the parties, with the opposite parties, and probably within the 14 days time, all these things can happen if everything goes very fast. We are not used to that time frames, but we need to get used to that. So let's take the next one. Anyone else wants to say something?
Yeah, this is Bhuneshwari. Hi. This is with this amendment, it looks like, IU is going to spend time in ensuring that the claims are admitted, both FC and OC, and accordingly the 14 days timeline, of the adjudicating authority can be adhered to. This is what I understand overall. But with respect to the dispute part, if they are able to take, why not? It can happen.
I mean, dispute would only come in Section 9 application, not in Section 7 application.
But in Section 9 also we are talking about it here. Of course, the amendment doesn't talk about Section 9. I agree. With respect to Section 7, yes, IU is a better mode so that, adjudicating authority can quickly, collect go through the application and admit it, and the timeline can be adhered to. I agree. Yes.
Yeah. Okay, ma'am. Thank you. Can we go forward, Nitin? Can you just scroll it? Now, this is the second one is the second proposal is also very important, because what we have seen is that by the time someone gets to know about some sort of a fraudulent transaction under section 66, 43, 51, 67, any other section where the avoidable transactions are taking place, it is time consuming, and the RP concerned takes time to file these applications before the adjudicating authority. So, and most of the time it happens is that by the time CIRP is finished, nobody is interested in pursuing these avoidable transactions applications. And even some NCLTs have even given some sort of judgments on these lines that application cannot continue beyond CIRP. However, now this amendment would specifically say that who is going to be pursuing this application after the CIRP ends, and how it is going to be taken care of in the resolution plan itself by the resolution applicant. How whenever some sort of a recovery is made by through these applications, how they are going to be taken care of by the resolution applicant in the resolution plan, and they need to provide for it in their plan. So let's open the discussion on this. So anyone would like to say something on this? That
hi, this is Bhuvaneshwari again.
Yes, ma'am.
Yeah, I was just going through this document. One is it is talking about, with reference to this section 19(1) is likely to be proposed to be amended to ensure that, in addition to the cooperation of the promoters, it will include the cooperation of any other person deemed necessary. That is what it says.
Yes.
But the practical problem what we are facing is not just section 19 application, filing the application. It is basically the order to be passed by the adjudicating authority. Anytime section 19 application is not being touched at all for months together. Afterwards, let me finish this. Afterwards, they ask a question that you have filed section 19 application. How did you prepare IM? How did you come out with a resolution plan without information? So we have time-bound processes. Because of their failure, they want us also to stop the work, and they stop questioning. Somehow we try to do, manage the information and proceed with all other processes, though 19(1) application is pending. So today the problem is how do we address the adjudicating? Why don't we bring the timeline of 14 at the time of admission? Similar thing we are able to bring in under section with respect to 19(1) applications. Okay, including any other person is very good. It's a good move. But even if I make the application including other persons or law is amended, what happens? Nothing happens. So I feel this amendment is meaningless.
Ma'am, I am agreeable to some extent to your suggestions. Most of the NCLTs have said that IRPs or RPs can ask for information from different stakeholders. Now, if it can be incorporated as in the statute itself, that would be a better option. Secondly, in many of the cases, we have seen that once 19(1) is filed, 19(2) is filed, the court starts giving directions to the CD or other stakeholders to provide such information. And by the time the CIRP is finished, there is no decision or a judgment on that specific application or order on that specific application. That you are right in that point that there is difficulty by the adjudicating authorities to give some sort of an order on section 19 applications. So Nitin, if you can just write ma'am's concerns and comments on that.
Hi, this is hello.
Hello.
Yes, sir.
Yeah, this is hello.
Yeah, we can hear you. Hello.
Sir, Mr. Ravinder Gupta, I am Rajendran from Chennai.
Yes, sir.
On the issue of section 19 application, I just want to take 2 minutes. Can I?
Sure. Please go ahead. Please go ahead.
See, there was an incident in one of the cases handled by me. The corporate debtor, the director does not know any of the antecedents or the information relating to the past. So I was depending mostly on the people who were with the company for a long time. The employees who have been with the company for 10 years, 15 years. Now, suddenly, one of the person who is, a relative of the directors, and he is otherwise unconnected with the company, he comes and threatens the employees that, I will hit you, I will kill you, I will murder, all sorts of foul language and everything. It's being done in the office of the corporate data. So when I file an application under section 19, also read with section 65, and also read with regulation 30. If you remember, there is one specific regulation, assistance of local district administration. Yes. Regulation 30 is there. The IRP or RP can make an application to the adjudicating authority seeking the assistance of the local district administration, discharging its duties under the code. So I felt intimidated that, this person can throw the every arrangement being made, cooperation being given into a disarray by threatening these people. But my application was forced to be withdrawn, stating that under 19 they are not the personnel, they are not the employee, he is not the person, a director or something. So under 19 you cannot file. Probably you file a police complaint. So the problem posed to the RP or during this period of CIRP is that when I'm seeking kind of a support from the court, the direction, and section 19 read with the other provisions, the adjudicating authority has a different view. It is the work to be done by the RP. You go to the local administration, make a police FIR. Is that the correct view? Now there is an amendment which is coming up, is a very good move. I also feel that any other person can be covered in that, but still the meaning of regulation 30, if you can kindly clarify on regulation 30 why it was brought. I think it is an application, it's a good kind of a provision for a party.
You should approach the correct person to give you redressal. If he fails to give you redressal, then you immediately go to the adjudicating authority stating that this person was supposed to give me some sort of redressal. He has not done so. It would affect my responsibilities. So ask for some sort of help from adjudicating authority, they would give it. But if you go there without approaching the concerned authorities, I don't think that is a right method to do that.
Okay, even for an order to restrain the person also, the correct person, correct forum is the administration.
Sir, you'll have to prove, you'll have, say, this is other than the subject we're talking about, but you'll have to prove before the court that you had used proper means to at least get a redressal from the concerned authorities, which they have refused to give.
Okay. Okay, so with this amendment, the situation will change, or how is it with this 19.1 amendment?
Can we take this offline? Because we have a lot to cover in this. We can speak offline.
Okay. Thank you, Mr. Gupta. Thank you.
Mr.
Hello, sir. This is CMA Manjula, insolvency professional as well.
Yes, ma'am.
I have a suggestion here. As Madam Bhuvaneshwari said that even when we file the transactions, NCLT doesn't have any authority to, it doesn't have any rather power to take any decision regarding this. So
regarding
even
what, ma'am? Regarding what, ma'am?
Regarding this PUEF transactions when we file.
Yeah.
NCLT doesn't take any, doesn't have any power basically to deal with this kind of transactions. And the case goes on and it will not be delayed. And once resolution plan comes, I don't know, these transactions will not be considered at all. So if how can this be addressed rather than, I think so NCLT should be given the power to address these transactions. This is what has happened in my practical experience. This is. So actually NCLT should be given power to deal with these transactions.
Ma'am, they have the powers. Probably there must be some factual information that has not been brought into the purview of adjudicating authority, but they have the powers to do the needful. If you can send me the actual comment that you want to make on this on the chat box, probably Nitin can incorporate it if it is okay.
Yes, sir. Definitely.
Right.
Definitely.
Mr. Nainesh Sanghavi, can you wanted to speak on section 19 application?
Yeah, like in the Companies Act, what earlier, once the application is being accepted, there is a power itself is given in the act. Once the application is accepted, it's a mandatory on the part of corporate debtors management or the promoters, directors, etc., to give all this seeking information mandatory. I fail to understand why this is being missing here in IBC code. Instead of filing an application in section 19, had it been at the time of accepting the application itself, like section 14, which is a mandatory in terms of putting an ad or appointment of an IRP, if it is being added itself over there, that once the order is passed, CRP applications itself, that point of time, if it is make it mandatory, then this kind of applications can be avoided, time can be saved.
This is something which is very close to my heart, that India has not used the directors. They have not put any brakes on the director's responsibility, right?
So
If we look at different jurisdictions, we see that the director's responsibility in terms of taking his company into liquidation or an insolvency situation. He is responsible for that, and there are penal provisions of doing that.
Yeah, there are many case law whereby directors or their goons are threatening to the RP and then approach the court thereafter and complete the process within the mandatory timeline itself is a big task. So there's a suggestion, if it can be put up at this point of time, possibly if it is possible.
Nitin, this thing is coming in a very, most of the IPs that I have been speaking to are being threatened by some sort of persons of the CD or the other. So why don't you just put in one comment that this specific proposal should include the executive as well.
Yeah, NCLT give direction thereafter to the police department, but it's a time consuming. Why not at the time of accepting the application itself?
Yeah, one more thing I would like to add here, even if NCLT has given direction to the police, the promoters have police also in their pockets.
Yeah.
So ma'am, you will have to have a work around that, work around those issues, because police.
So it is better that it is mandatory for the directors themselves to part with the information on admission.
Correct, exactly. So it make it mandatory at that point of time, where there is NCLT gives the directions, correct, that to put an ad in application form number A, etc. Same time, if it is mandatory that whatever information seeking by the IRP, it is a mandatory on that part, or make it in the law itself certain kind of penal provision. If they don't provide, in that case, the process becomes easy.
Section 17, 18, 19, in fact, rather than RP seeking information, it should that RP word should be
provided.
Directors should provide.
Correct. Anyway.
Yeah, this is Shailin Singh. May I speak? This is Shailin Singh. I'm an advocate and Supreme Court, and I'm also a solvency professional. In 19.2, I agree to this point of view. One aspect is there has to be a law on this point, that whatever the direction RP has issued to corporate debtor, if this direction falls under certain category, it should be a law. The second important thing is the Honorable NCLT should decide this application in time-bound manner. Say, for instance, if the application is listed, it has to be decided on priority basis. So these things will go. So the most of the problem is that in many of the cases, where I have conducted as in CIRP also, where I have represented the resolution professional also, COC also, I have seen those 19.2 applications are not decided. It takes a lot of time, because they write certain kind of a mail, they give some information, half information, they blame on others, this information has been destroyed, something has happened. So how to deal with this kind of a situation? This is a great problem which we are facing. So even if we say for instance, if it is made made a law, as my previous speaker has spoken, said that has to be made a law altogether, once whatever information has been asked by the RP should be mandatorily provided by the corporate debtor, or whether there has to be a time bound if the Honorable NCLT immediately take up this matter and decide in a time bound manner, say for instance in 15 days. Once the application is moved, it has to be decided in 15 days time. So it also solves a lot of a problem, because many CIRP processes are delayed only because of 19.2 application remain pending, undecided, unjudicated upon. That is my concern.
So the law should be, the objective of the law should be twofold. One, reduce the workload of the NCLT. That is can be happen only instead of putting them heard an application on early stage. Rather, if it make it a law that once the application accepted, it is a mandatory on the part of corporate data. If they don't adhere to, let them put some penal provision. In the Companies Act, I am 100% sure there is some penal provision. If they fail, there is some jail terms also there. So if this kind of penalties are there, then no corporate debtor, rather take any step to stop giving information.
But as far as I understand, the provision of a law is that nobody can be punished until he has given a proper chance of due process of law. Due process of law. The Constitution says there has to be due process of law.
I fully agree with you, but at the same time, if the law is there, to correct the situation is that IP has to run pillar to post. They have to file an application in 19 and then keep quiet.
So most of the amendments that have come out, most of you are hit by the section 19 application.
Correct.
Can you wanted to say something?
Yeah, as regards section 19 application, we of course the court says that we should be supported by everyone, including creditors and stakeholders. It's also the reality that creditors themselves also don't have documents, or even if they have documents, they don't share, because they themselves found it there is something wrong in it. That so that we can find out and trace the documents. Even the secured creditors don't have the documents of the property. So actually, in the last round of suggestion, when IBB and MCA invited the suggestion, I had given the suggestion that unless the information of CD is available with NCLT, the application should not be admitted. And I have given the list of items, because we have list of items we need to complete the process. And I said, this NCLT should gather. If the NCLT itself cannot gather from CD, how IP will be expected to do? You issue the notice and all that. If this happens, all problem gets on.
Nitin, can you just note down this suggestion of Deepti ma'am?
Yeah, I agree with Deepti Mehta. What she says is absolutely correct.
Don't admit only, no, because you can't punish anyone. You will give section 19 application, then you file contempt of court application, then again you said still they are not giving. Rather than what you need is the information. If that information is deposited, made it compulsory for the corporate debtor, creditor, everyone. The creditor wants the application to be admitted. IRP is appointed. Now they don't have information. They don't want to gather. They don't want to pay. If you allow the process to start, entire machinery start. Don't start the process when you know there is a defect itself in that and it will not be over. Get the information and then only start. If it is available, why can't it be also part of that process? Then everyone problem gets solved. Majority.
Madam, I beg to differ. I beg to differ with Madam Deepti Mehta on this point. How the CIRP process will be initiated only on the basis, if Madam is saying it will only start when all the information is available. So in that case, the most of the CIRP cases will not at all start. So entire purpose will be frustrated. Because how the financial creditor, I say for instance, I'll give you one important case. I was representing resolution professional in one important case. I can't name the case. In that case, even corporate debtor and financial creditor were in connivance. They did not want to provide the information.
Okay.
What was the reason? So 19.2 is such unless some law is made in such a way, unless the parliament passes a law, that whatever information has sought by IP has to mandatorily provided. Otherwise, RP has to be empowered.
Sir, that was what I was saying, that director's responsibility needs to be taken care of.
One important point is process is started, it can't be stopped. My suggestion, because that process once started, IRP appointed, process started, timeline started, all action to be taken in timeline. You can't stop that. So if you want the process to be started, unless you know even the registered office location, the assets location, the record location, you don't know anything. And you start the process.
Ma'am, I would say
no, ma'am, I would say on this point, say for instance, somebody has given an office in XYZ area.
Amitji, we
Section 7 application is filed. Say for instance, Section 7 application.
Amitji, we need to go ahead on this. Let's. What I would suggest is that if the director's responsibilities are taken care of by the Act, and there are certain penal provisions provided for that, for wrongful trading or fraudulent transaction or not providing information, then they should be penalized immediately without the Section 19 application being sub judice for 6 to 10 months, where nothing happens on an application, right? So let's Mr. Devang needs to say something.
Sir, I would like to proceed beyond Section 19.
Yeah.
Of course, the points of both the learned speakers, Diptiben and Mr. Singh were maybe perfect. One maybe on this particular point would be within 15 days they have to submit everything, and then the application would be accepted. The directors, consultants, everyone. So 15 days time is automatically given, and then the application is accepted. If they don't give in 15 days, then they have to face the consequences. Midway between the two could be done so that even the avoidance of application would not be there, where Mr. Singh said there is connivance between financial creditor and the promoter has been seen a couple of times. Now proceeding further on the same point, on para 321, para 3, it says that the avoidance application, if not filed by RP or liquidator, can be filed by any creditor or financial creditor. I would make a suggestion that world over, it is only the administrator who looks into avoidance transaction. So IRP, RP and liquidator should be strengthened rather than creditor being given an opportunity to file an application. The reason is maybe sufficient information would not be given. Maybe even a creditor would not give an information. And then further IPs would face hardship on allegations that they have not filed application, and a weak application will be filed by a creditor. The creditor may not only be a banking or a financial institution governed by RBI. It could be someone else also. On one point, they don't want to be governed by regulators, IBBI. And they say they are governed by RBI. And on second point, RBI already has a norm. So who is stopping them from filing application otherwise? Why do they want to come to an insolvency process and say that IP has not filed an application? Even if they want to be given a right to be filed an application, they may file a parallel application, or only an IP should have a right to file an application. Provisions could be misused. An entire CIRP could be planned, IP not allowed to function as per the provisions of the code, creating hindrances, then again an IP is blamed, and then a weak application is filed, and then everything moves on as planned. So rather an IP should be strengthened, and even otherwise they have a right to file an application. RBI has already put a norm on them to file an application. Why are they waiting for? And even if they want to file under IPC, it could be a parallel application, but not allegations that RP or IP or liquidator has not filed application, so we are filing. Maybe those are my suggestions, and I leave it open to the house, sir.
Thank you, Devangji. Bhuvaneshwari Devi, Bhuvaneshwari Ramanathan ji.
Yes, yes. This is with respect to the section 25 to apply the amendment, that even the COC creditor can file application. It's going to bring a lot of conflict between the COC members and the RP. RP is basically representing the COC and their interest, and accordingly he is filing application to enhance the value of the assets for the benefit of the stakeholders, which includes COC. Again, bringing him, I don't know why it is required to be done. At the most, what they can think of is that in case during CIRP it is not done, during liquidation, if it is anyway during CIRP has not done, liquidator is also not doing, they can do it. But instead of COC pushing the the resolution professional, asking the creditor to file application is going to bring in a lot of pressure and a conflict of interest. That's how I see this.
So this is a valid point. Probably Nitin can note this down.
Because whenever we appear in the court and COC members appears, the court says that RP is representing the COC, so you don't talk. They don't even allow the COC member to talk. Now if the law is going to allow the COC member to file an application, it is going to really bring in conflict of interest, and it will discourage the RP actually. And, it's already we are working under a lot of pressure on day-to-day basis.
Okay.
RP.
Okay, ma'am, that has been noted.
Thank you.
And IP is expected to even find out if some fraudulent transaction has been done by a financial creditor and report on the same. In such situations, definitely there is a conflict of interest when a person who is being maybe alleged of a fraud himself is given a right to maybe file maybe act as judge of his own cause.
Deepti ma'am, you want to say something? Your hand is raised.
It was earlier raised. Sorry.
Okay. Can we go ahead on this? Section 47 may be amended to disallow members or partners of the corporate debtor for filing applications to avoid an undervalued transaction.
That looks fine.
Yeah, okay.
Yeah.
Nathan, can we just scroll a bit? Important thing is continuation of proceeding after approval of resolution plan. So we open the discussion on this now.
Yeah, again, this is Bhuvaneshwari. I'm not in agreement with this because many times, we observe that the assets are mostly diverted, and inside because of the CIRP timeline, we are forced to come out with a resolution plan with the leftover business or the assets. And the avoidable transactions have a lot of bearing on the resolution plan and the resolution applicants. And the resolution applicant is submitting it, keeping in mind that one day or other this is going to come and creditors are expecting. So keeping it, on and without any timeline and pushing only the resolution plan does not make sense. And Delhi High Court also passed the order saying that all other applications will become infructuous once resolution plan is approved. So I feel, we should not just pull on this avoidance application after resolution plan. For resolution plan, this is one way of closing the avoidance transaction by passing orders before the resolution plan. There's a push. So I think we should not dilute it by taking it after the resolution plan approval.
Ma'am, just one thing that I would like to ask you is that if the avoidance application is discharged by the closure of CIRP, who is going to punish the directors for any sort of avoidance?
See, the intention of IBC is not first to punish. The preamble itself says that it is enhancing the value of the assets. That is the intention. Otherwise, we have to send all the promoters to jail.
Ma'am, that was not the intention of my saying that. See, every act needs a closure. So if what you are saying, if there is no closure to a wrongful transaction or an avoidance transaction, then probably you're giving some sort of a push to people to do this because they would feel that they would not be punished in any way.
No. What I'm saying is that the application for avoidance transaction has to be adjudicated before
within the CIRP
plan is approved. That's what I'm saying. Number one, I'm not saying that it should not be done. Second thing, in my own case, it has happened. Sometimes the resolution plan has a dependency on the avoidance application. When that is the case, by keeping it pending, even after the approval of the resolution plan, it doesn't serve the purpose. I am seeing that every time there's an amendment coming in, we are trying to dilute the law more and more. That is what this is, a sort of dilution. By
let's take a situation where the CIRP has finished and the avoidance application is still pending before the court.
Yeah.
Okay, ma'am. So what this amendment is trying to do is trying to get out a framework wherein probably, I'm not saying it might be the case, but probably the RP can follow it up on behalf of the resolution applicant, or some other resolution applicant can follow it up on his own behalf, so that in the whatever money that has to be taken back, or whatever quantum of funds that have been avoided, or some sort of undervalued transaction or PUF transaction has taken place, that would come back to the resolution applicant, and it would be taken care of by resolution applicant in his resolution plan and distributed between various creditors as per the resolution plan. This is my understanding of this proposed amendment is, and what I think is that it would I think it is fine with me till the time RP is not, I mean, the RP's, when the RP's jobs finishes, then he can have another job of pursuing these sort of transactions on behalf of the resolution applicant or on the behalf of the erstwhile COC.
I'm sorry, I beg to differ here. See, as such, we are not able to make the adjudicating authority pass orders, and we are talking about certain amendments and all, even for the admission of the case. And by saying that the avoidance application will continue after the approval of the resolution plan, we are giving one more threat to the adjudicating authority to keep this endlessly. Number one. Number two, in my own case, one resolution plan, or there's in one resolution plan, there's a dependency on the avoidance application. Unless avoidance application is passed, the resolution plan cannot be passed because sufficient, sizable amount funds were diverted. When that is the case, when we are trying to do our job, and if the law says that it can be continued, then it is meaningless. And where is the question of time-bound process? And I think this is a dilution of the law. I'm not in agreement with this. We have gone through so much of avoidance transactions, and not many orders are there even today. Like admission, so many orders are there. Resolution plan approval, many orders. Avoidance application, how many orders have been passed by the judiciary till date? And by giving this, we are only going to pull on with the avoidance transactions instead of passing avoidance orders and then realizing the funds. That's my opinion. This is a very, very dangerous thing they are trying to amend.
Okay.
Suggestion on this.
Can I also say something?
Yeah, please go ahead.
Yeah.
One way out would be, one way, maybe one suggestion could be.
Devangji, can you just talk after Mr. Shailendra Singh?
Surely, sir. I'm very sorry.
What I mean to say is that the whole purpose of CIRP is to maximizing the value of assets of corporate debtor while keeping in the interest of stakeholders. It is a time-bound process. Once the resolution plan has been approved by the Honorable NCLT, by the court, it means the end of all litigations. So therefore, it is necessary that all those applications, whether avoidable transaction, 19(2) applications, whatever applications are there, that has to be adjudicated upon earlier, except in extraordinary circumstances. Okay. Where supervisory role of RP will come, RP will become a monitoring committee. Member will monitor the things. So that is except in extraordinary situation, this should not be allowed to happen. Otherwise, there will be difficulty in after even approval of resolution plan. There will be so many challenges and nothing will fructify. That is that I want to add.
Okay, thank you. Ms. Sujata?
I would like to point out is that oftentimes what happens is that the transactions are not apparent on the face of it. They are complicated and linked to one another. It's like a chain which keeps someone unraveling. So if you have a limit to the time, it is possible that you have started and put in one application for avoidance of a particular transaction, and quite late in the day, you realize there is something else as well. If you close the chapter before the resolution plan is approved, there are chances that you might miss out on some major transaction. For instance, in my own case, where I am a liquidator, I have initiated during liquidation. It's a different matter that there was, of course, in this case, there is no resolution plan. But if that is the cutoff, then I would fear that a lot of substantial transactions may be missed out.
So we have different opinions on this specific point. Let's go ahead and talk about the change in look back period, which is very important.
I would like to add something here.
Yes,
in fact, on this point. I think we are discussing on the avoidance application filed by the CD whose plan is to be approved. There are certain cases wherein in avoidance application filed by one RP, other CDs are also party to the avoidance application, and that CD's plan is getting approved. So I think if there is any avoidance application wherein a CD is a party, the plan of that CD should not be approved unless the avoidance application is decided, because once the plan is approved, then the avoidance application filed by another RP becomes an infractuous act. That has no meaning. once the plan is approved by the another CD. So that point should be considered somewhere, which is not being addressed anywhere in the suggestion. Actually.
So, okay, ma'am. That's been noted, ma'am.
I also want to add, with respect to avoidance applications, there's a 75-day, 115, 135-day, all those timelines are given to ensure that it is filed on time, and then, it is adjudicated accordingly. And when that timeline is given, what is the need to proceed this even after the resolution plan approval? I'm seeing contradictory things here in the law.
So are you going to shut the door on subsequent discovery? That is my point. What happens if you discover on the 200th day that there is a huge property which has been siphoned off? Will you shut your eye, or you say, okay, my 175 days are over, I do not proceed?
May I add on this one? May I add on this
File
one?
application. See, even after the 135 days also, you can file application, additional application or an amendment if required, if you come across additional transactions. But by keeping all the avoidance transactions, this is going to allow the continuation of all the avoidance transactions after the approval of the resolution plan, which is very, very dangerous. Additional things and all, if it is there, we can file additional application, but that cannot happen in this process.
Okay, can we go ahead?
Yeah, and I request ICSI to take up this seriously, because this is a very, very dangerous amendment your MCA is proposing. Thank you.
Sure, ma'am. Ma'am, this is Nitin Satija. I was, in fact, I also have a view on this. And that's my personal view. Can we leave it to discretion of some authority to extend the period beyond the resolution period?
Nitin,
to pursue these kind of transactions.
Yeah, Nitin, what we see with the adjudicating authorities is that they don't touch the avoidance applications at all. And if we leave it to the discretion in black and white, they are going to take all the avoidance applications after the approval of the resolution plan. And where is the question of this time-bound process? Why RP has to continue lifelong because of this avoidance transaction? He has to move on with other assignments, and the corporate, the stakeholders should get the money which was avoided or which transactions money has been diverted. It should come back as quickly as possible instead of pulling on endlessly. We have to bring a solution to the problem than saying that, I will postpone it. And it's so hard, I'm very sorry to say this, it is very, very hard to push the adjudicating authorities to take up an application and pass orders. And we should not make amendments giving them the rope, saying that the law itself says that it can go after the resolution plan. Why are you in a hurry? Today we are trying to push the hand, so I feel this is very, very dangerous. Please stop it. Thank you.
So may I add on this
Agree,
one?
ma'am. Agree, ma'am.
May I add on this point? So that is why the word I have used was that except in very extraordinary situation, this should not be allowed. If there is some extraordinary situation, NCLT is of the view, or we have to frame the law accordingly. If you request the law to be framed accordingly, so except in extraordinary situations, this should not be allowed. Once the CIRP period is over, resolution plan has been approved, every should come to the close. That is what.
Okay, Shreya, that has been noted. Let's go to the next, the D part of it.
Just if I may add.
Yeah.
This is Rajan Agarwal here.
Yes.
So my humble view on this would be, so as far as adjudication of PUFE transaction is concerned, I believe it is not a simple process. It has to be given the time it takes. And it will take time only because decisions on PUFE transactions are basically in the nature of a penal provision, wherein you are making the, say, suspended director accountable for transactions done by him. I believe there may be times where the transactions have to be analyzed, adjudicated by a court of competent jurisdiction, and they may be based on some contracts. Transactions may be based on some contracts, and it may not be possible to adjudicate them at the NCLT. So the only good solution to this could be, in the order of resolution, it is appropriately noted that the PUFE applications will go on later on, and at the same time, the resolution plan should adequately provide as to if there is any inflow due to proof transactions, then to whom that will flow. If that is mentioned properly in the resolution plan, and if the adjudicating authority mentions in the order for resolution stating that proof transactions to be taken separately, I believe all this can be taken care of. And I think that it is not possible to take an order on the PUFE transactions because before an order of resolution is taken. It may not be possible because the timelines for taking resolution has to be maintained. The sanctity of that has to be maintained.
Okay.
Thank you, sir.
Okay. Thank you. That's been noted. So Nitin, can we go to the part D of it? Change in the look back period. This is important. Now this amendment, the proposed amendment actually takes care of the issues for the time frame that the adjudicating authority takes between the filing of the petition and for the passing an order of admission. So what it basically says is that the look back period should start from the date of filing and not from the date of commencement. And the look back period can also include the timeline between the date of filing and the date of commencement. Your views, please. All agreeable on this? I think that there shouldn't be any.
Yes, to some extent this can help. But
Yeah.
what you see is that sometimes, the transaction has happened maybe 4 years or 5 years. Even with this amendment, we may not be able to cover all those things under the relevant sections. But anyway, it is a relaxation in the look back period so that some more transactions can be brought into this.
But ma'am, for the
look back period is okay. According to me, that will solve many problems.
Yeah.
It is okay. Because it should be considered from date of filing, because it takes sometimes 6 months or 1 year, even admission takes a lot of time. So look back period should start from the date of filing. It's okay. I agree on this point.
Oh, everyone agreeable on this? I think this is a nice amendment.
Yeah.
Yes.
Let's go forward, Nitin. Time period for approval of resolution plans.
Sir, I think Mrs. Sampath has raised his hand. So
okay.
Maybe he wants to say something.
Sir, maybe a question. There have been a lot of delays between the date of pronouncement of order and the date of receipt of order. So whatever transactions that happen between the date of pronouncement of order and the date of order, maybe even that should be included in look back period. In my humble understanding, I leave it again to the House to opine on the same, sir.
Devang, when the order is passed, that is the date of the passing of the order. So the look back period would either start from that date or from the date of filing. So whatever happens after that, probably after when you come to know or an IP comes to know about the order, that would also be included in that.
Thank you very much.
If one thing more can be included in that moratorium should start from the date of filing. You
can file an application for that.
Especially in section 7.
Yeah, you can file an application for that.
We file an application. This should be in section 7 application when we have got the exact default period of default and date, certification, etc. So that period can also start immediately with the application. Sure.
Many of the times when an application is filed, that there is some sort of a issue with the CD going bad in terms of during the time frame between the filing is done and the order is passed. Courts have granted some sort of moratoriums in this regard. Right. So let's take up the next one, the time period for approval of resolution plans. So what effectively this amendment states is that A should be given 30 days for approving or rejecting a plan, and if it is not approved, they should give a reason for that. So I think this is a welcome step because a lot of IPs would be aware that time frame has increased from a year and a half to 2 years probably.
May I add something on this point?
Yes, sir.
I want to add one thing. Say, for instance, a checklist has to be provided to A, adjudicating authority. If they come to the checklist, they see all the checklist, everything is according to checklist, then resolution plan has to be approved. because many of the resolution plans are not approved. They are taking time unnecessary because adjudicating authority is not required to go into any other question except to see those checklists, whether that meets the parameter. So that parameters may be made in the form of checklist. So that will solve a lot of problem because it will become easier for the adjudicating authority. Also, it will be easier for the council who is representing. They will make this checklist parameters are met, and they will immediately pass the resolution.
Shalendraji, what this proposed amendment says that it is up to them to decide within 30 days. They use a checklist or any other method or go through the plan by themselves. Because normally a judicial member would not be aware of the technical issues which would be taken care of by the technical member in the NCLT. So what this amendment says, that 30 days is the maximum time frame being given to them, and thereafter if there is a delay, they need to state a reason for that, why it has been delayed. So in terms of a checklist, that is the prerogative of the presiding officer, whether whatever method they want to use to fasten the process of approval or rejecting a plan.
Otherwise, it is welcome step. Very, very, very
okay.
Good.
Thanks. Thank you. Anybody else on this point, or should we go ahead? The next is, can we go to the fourth one, the closure of voluntary liquidation process? Any comments on this, that voluntary liquidation process can be stopped midway in case the CD has got some sort of a new assignment or a new contract or has some good business opportunity? Then it can, as per the special resolution, and the creditors representing 2/3 in value can, passing that resolution, can this be stopped, or
yes,
this is not a right way to go about it?
According to me, it is a right way to go. This would help because it will help to achieve the objective of IBC.
Yes, and this is basically being a voluntary process. If a person has a change of mind in between, so they should be given that chance to get out of the process.
Correct. Because this is a voluntary process by them only. So if voluntarily they have come out with certain things, some development has happened, they can exercise the discretion. That is welcome.
Sir, of course, this is a very welcome step. But do we need to give one rider that maybe a report by IP or someone who is required that this withdrawal is not being misused? Maybe everything is very goody at the time of going into voluntary liquidation.
Sir, you're putting more responsibilities on IP by this.
Then I'll leave it, sir. I'll leave it because things will come up from cupboard. It will go for withdrawal, and then section 7 and 9 application will come. When things come up for cupboard, the business becomes viable, withdrawal happens, and then section 7 and 9 application comes. I'll leave it to the house and yourself, sir.
Because this become otherwise also, because what happens, this only can happen, attract some kind of a money has come through some money laundering, something like this. If you're talking about this, certification will not be possible at the end of IP, I think.
Agreed, sir. Agreed, sir.
IPs have already been put into a lot of stress.
Overburden.
So let's not make them more stressful.
Rather here, it should put the restrictions that if application comes for the voluntary liquidation.
Yes, sir.
Hello.
Yes, sir. Yes, sir. Please speak.
So here my suggestion, once the application for withdrawal for the voluntary liquidation comes, it should be a mandatory, or it should be put up in the law itself, whereby the corporate debtors, or they should not come up with any application by themselves once again after the period of a certain number of years, maybe 2 years or 3 years. Till that point of time, they are not allowed to file any other application.
You're talking that once a company has gone through a voluntary liquidation process, if
they
the
should
promoters
not come up once again after the period of certain number of years. They are not being allowed. That's what exactly.
Sir, I couldn't understand you. If a company has gone into a liquidation and that liquidation has completed and the company has been.
No, I'm not saying completed. I'm not saying completed. Here, the amendment which has come, allowing them to withdraw application, correct?
Yes, yeah.
The amendment we are talking about withdrawal.
Yeah.
I said that before accepting this application, there should be some restrictions on them whereby they should not come out, they should not change again their mind after 6 months or 1 year that let's go once again and waste someone time.
But that should only be limited to a voluntary liquidation process.
I'm talking only voluntarily. I'm talking
not
only
under
voluntarily.
section 7 or 9.
No. I'm only voluntarily.
This is a good suggestion. Yes. Yeah. So,
sir, maybe the suggestion could be modified.
Yeah.
Of course, the process of section 7, 9 or 10 application can continue. However, unlimited liability disclosure which or affidavit which the directors have given, they will continue for a period of 5 years. So that it will not be a voluntary liquidation or something may not be used to stall a process of section 9 or section 7 application.
5 years is a too harsh period. In the change of many things, business takes place. No one can offer those kinds of guarantee. 2 years is I believe it's all right.
Okay, sir.
I think we cannot put so much restriction on the business.
Exactly. Yeah, you can put certain number of 1 or 2 years restriction. They should not come up once again in application after 6 months or 1 year. So
restriction, rather it should be supervisory kind.
Yeah.
So technically speaking, if a business is viable, who stops the promoters from forming another company? Why do they want to revive the same company? That is one a particular question which comes up. If they have thought very carefully and come into voluntary liquidation, then why suddenly maybe a viable business comes up and suddenly they go up, and maybe if a section 7 or 9 application comes up later on, maybe the entire process has to be thought about, and then maybe suggestions have to come up.
See, there is a section called section 11 whereby person is not entitled to make an application, in which there is a period for 12 months, correct? So what my suggestion here in the section 11 itself, can modification takes place whereby if anyone want to withdraw the application in voluntary liquidation, instead of 1 year, it can be put as a 2 years. That's all. There is already particular sections is there that if anyone who withdraw the application, they are not being allowed to file another application within the period of 12 months. Hello.
Yes. Okay. That's a good suggestion.
I've done it.
Okay. So let's go to the IBC fund, the 5th part of it.
Yeah, that is extremely important.
So no, actually, this amendment or the proposed amendment is very important in terms of providing for some sort of a fund wherein it takes care of the insolvency costs or some other costs if they are there. So in terms of MSMEs getting into liquidations or insolvencies, normally MSMEs do not have a high asset base. So this fund would actually help out those sort of MSMEs as and when the individual insolvency comes in. That is my take on this. Probably you might have a different view. Yes, please. It's open for comments now.
See, this section 224 is an external fund. It's not an internal fund. So here, who will contribute? The contribution made by the either central government or from the any other person. Now,
Yes,
question:
sir.
Central government is fine. Central government, or everybody expect that central government should contribute.
Yeah.
But the question arises: will this MSME itself doesn't have a money? How can they put a fund on in the IBC? And even if they put, they have been allowed to use only to the extent of whatever they have made a contribution. So I don't know how far the validity of
this fund is basically to be used anytime wherever there is some sort of a issue with when the insolvency costs cannot be taken care of by the assets of the CD. Right.
Correct.
So what happens then? Who funds that cost? That means if a CD cannot fund some sort of a cost of insolvency cost, whether CRP should be stopped or it should be allowed to continue, because I'll tell you why. In many jurisdictions worldwide, every government has a these sort of contingency funds, wherein when the insolvency of any person starts and there are no asset base or less asset base which cannot fund the cost of insolvency, then the government steps in and provides those costs for the insolvency of the debtor.
Yeah, but as on date, only financial creditors only has to fund, or operational creditors.
Yeah.
In case if there is no funds available, then why at the first place you require to go into any CIRP or liquidation? Nothing is there, correct? So what is the point?
Let's say if there are no financial creditors, then there are only operational creditors. Or someone is speaking. Nitin, can you just...
Hello.
Hello.
Yes, sir.
So let's first let the topic of discussion be from where can the IBC funds, this fund the funds can come from. It can come from the central government. It can come from the state government. Probably it could be included in the CSR funding.
Yes, CSR funding, that is very important. I was going to add it. If the CSR funding is made certain percentage in CSR funding, that will solve all the purpose. Because this is a very welcome steps. IBC fund is very welcome steps. If the CSR funding is added, that will solve many problems.
And what I think is that this fund would be used in terms whenever the individual insolvency comes in, the steps in.
Yes, correct. Because that time, yes.
So that is important at that point in time.
Because otherwise what happened in many cases, IP has to actually start spending his own funds and he is left with nothing, and then he's chasing for his own funds.
Yes, and probably when a company, for example, a company or a legal person is getting into an insolvency and the funds which are required by the RP or the IRP are not provided by the creditors, and the courts find that there is no funds with the creditors as well, probably these funds can be used.
And after that, yes, this fund can be used, and after certain period, this fund can be recovered from that person and can be put in again.
Exactly. So this can be another fund use of this specific IBC fund.
Yes, right. It is very welcome step. It's very good.
Any views on this? Other views?
As on date, even the last amendment which has come, whereby certain penal provision has put on IRP and RP, at that point of time, I thought that whatever penalty which is imposed for any irregularities committed by IRP or an RP, I was under an impression that will be put or deposited into IBC fund, or for the training purpose or for the knowledge, updation of the knowledge to the IRP and RP. But I was utterly surprised that whatever penalty which is being imposed on them, that will be used for the internal fund. That means internal fund means for the benefit of the IBBI, for the benefit of the board.
Now this is a debatable question. Debatable point.
Now tell me, if I am a human being, I may make some mistake. Maybe either I am not updated or for the lack of my knowledge, and for which whatever penalty imposed on me, and those penalty or those money which is used for the purpose of internal benefit or the expenses incurred by them by the board member. Now tell me, who will improve me? Who will going to help me to increase my knowledge or update my knowledge? Only the board.
Sir, what we are talking about is a huge amount of funds that we're talking about. If you say in terms of the penalties imposed upon insolvency professionals, that might be 2 months or 3 months of their remuneration. That would be, I think, peanuts in terms of what we are thinking in these lines on whatever IBC fund we are talking about. We're talking about millions and millions of rupees in this. So that
I'm saying those funds, instead of depositing into the internal fund, it should be deposited to the external fund. That's exactly I'm saying.
Okay. So that is also one of the ways to increase funding in the IBC fund.
Exactly. Why to benefit to the board member for their salary and etc. It should be goes to the external fund. Let's to be used by the general public at a large.
I think that their salary will be taken care of by the.
I said it's my suggestion. I am not saying only for the purpose of salary. I'm just saying it should be for the general benefit for the public at a large, or I mean to the corporate.
Yeah. So any more views on this?
Excuse me, sir. Hello.
The Kanti sir has also joined.
Hello.
Hello.
Can I add, sir?
Sure, sure.
Sir, here I feel that it should not go to the internal fund of IBC because it's, I take a plea that it's a conflict of interest. Means it incentivizes IBBI to impose more penalties on us in order to increase the funding.
Exactly. That's what I'm saying.
May I just clarify? IBBI should not be incentivized.
May I just clarify? The IBC fund is not for internal purposes of IBBI. It will be, all the collections into the fund will be utilized in a manner as designated by the central government through an administrator appointed by the central government. Those frameworks rules have not been made, and this 5.2 is talking about that, to make a framework how that fund will be utilized. It is not for IBBI internal purposes.
Yes.
Okay, just to clarify.
Thank you.
Excuse me. Hello.
जी बोलिए.
My suggestion is that actually government should make the fund from the CSR. They have to make a provision in corporate social responsibility. Some part of the fund will the company can make contribution in this IBC fund, and this IBC fund may be for 500 or 1,000 crore. Then initially, because government is the responsible to early regulation of the corporate insolvency, whatever it is, liquidation. So it should, government should give some fund to the IRP. They can utilize that fund to initiate this CIRP process, and after that they can recover and deposit the amount on this fund back.
Your suggestions are noted, Anilji, and this suggestion is also noted down that that it should be included in the CSR funding if possible, so that the money can have a good flow of money into IBC fund.
And my second suggestion was that suppose when we are giving the public notice for our just transaction, so we have to be maintaining if somebody have some information about the subject company, if there is a misappropriation of fund or misutilization of fund or any wrong thing is going on this company, so they have to bring to the knowledge the IRP. The IRP can take the necessary action. Otherwise, they are giving 30 or this is 70 days or 100 days. It will not make any difference if they have the information.
So you're talking about the avoidance transactions part of it?
Yes.
So
avoidance.
So that your suggestions are being noted down. So what is your suggestion actually, which you like to?
My suggestion is that when we are initially giving the public notice, so there is a one column should be there. If there anybody have the information about the company, if there is wrongdoing in this last 1 and 2 years, so then it will bring to the notice of the IRP or RP. Then he can take necessary action. And
so we're talking about self-incrimination here. So I don't think that would be possible. Anyway,
if they are putting the more responsibility to the RP, IRP, so what is this in this problem? Because they have to be plug out the lot of fund is here and there. It will give early information to the IRP that he can do something. Otherwise, we are making lot of transaction audit and forensic audit and paying a lot of money to these people and not doing anything.
Nitin has noted down these suggestions. I think we have almost covered this. Anything else to be said by anyone on this point of IBC fund?
I do have one small thing to say that, I mean, I'm really not in favor of CSR fund going to IBC. Okay. There are much more worthier causes for which they ought to be used. And at the end of the day, IBC is about delinquent companies with all the objectives that we have that the company should be saved. It's also equally true that some, as per theory of evolution, some also should be allowed to die. So everything is not worth saving. There is a prioritization. Yes, in fact, the note itself talks of where the funds will come from. They are talking of the Companies Act liquidation fund, which is there with the High Court, the High Court, both 56 Act and later on. There are fines which are imposed by the IBB, of course, on IPs. But there are also fines which are imposed or penalties by the adjudicating authorities. Today, they are going into usually the Prime Minister's fund, etc., etc. I mean, they say, okay, deposit in the PM fund. I mean, since these are connected together, so that could be the source. All penalties imposed by the adjudicating authority or the NCLAT on an IBC proceeding should go to IBC fund, because that's how under winding up, that's how the high courts operate. I mean, they collect this money primarily from fines.
I think what we are talking about is not the entire CSR fund. What we are talking about is some part of CSR, very small part of CSR funds.
But you know, the two are different.
Running up the economy is equally important. If the more businesses are coming up, they are saved, more people are getting job. It is actually blood. Economy is a blood.
No, so I agree, Mr. Singh.
Important.
Yes, so, but you know, the company which doesn't have money to run a CIRP process is anyway dead. Okay, it's going through the motions. Antim kriya karne ke liye, you know, at that time it should be less.
I think the point is not the company is dead, which company is funding about. This IBC is funding about those companies. Sometimes such a position occurred when the IP insolvency professional is unable to attract any fund, to get any funds. So from where he will get the funds? So this is talking about that kind of amendment where contingency funds are available. Now that funds can be recovered and again deposited to that fund. So this is, I think, the objective of this, if I'm not wrong.
Yeah, they have also said where the sources are likely to be. Yeah. Those are specifically mentioned in the note. But CSR is something which personally, I just wanted to, my personal viewpoint, it has better utilization.
And like I said before, I think where many jurisdictions use these funds for individual insolvencies where there is no asset base actually, right? So this at this point in time coming right now, it seems that the
fast track processes where the debtor himself is of very low income side, etc. Yes, that is where these are used.
So this is a welcome step actually. So
yeah, one additional suggestion on this particular point would be, whenever this fund is utilized, let it be compulsorily treated as interim finance with some coupon rate, maybe marginal cost of lending rate plus some percent, or maybe 9% or 12%, so that if a company is having funds and not have interim finance or funding not given by COC members, let this be treated as interim finance and let there be some revenue on the funding also, if possible. If there's no funds, even otherwise, the money is not going to come back. So when there are funds, let it be treated as interim finance and get a coupon rate.
Okay, sir. Noted. Anyone else who wants to say something on this?
I think interim finance, this is the very good idea. The interim finance, it can be utilized because there are certain companies which they have come up. They are charging high rate of interest on interim finance, say for instance 24%, etc. So if some marginal rate of nominal 9% or something kind of a rate of interim finance can be provided, it can save both sides.
Excuse me. I also agree on the same point that interim finance should be made available at the nominal rate or the current market rate, not at the higher rate. That is also my point.
Okay, sir.
Can I come? Excuse me?
Please go ahead.
My name is GS Kathuria and I want to speak on that CSR, the funding to be made available to the company for the insolvency cost. See, typically what I have seen is when the company gets into the insolvency, especially under Section 7, the FC with a lot of experience in the funding are able to figure out whether the longevity of the company is there or not. I mean, whether the company's operation can be retrieved and the value maximized. Now, if those guys, set of intelligent people, they are not able to convince themselves to fund the CIRP cost or the interim process, why should the CSR or somebody else's money be used for this purpose? I mean, no. Yeah, I'm through.
This is something which is argumentative, and your views are there. So we'll take note of that.
No, my views is no. This is not an argument. My view is that it should not be used. You know, the person who are at the hem of the company during the process, if they are not willing to shell out something to salvage the value which now is theirs, you know, realistically, because saving the company is also, in fact, is the motto. And it is only when the company gets saved, they will get the better values. So with this dual objective of getting the better values and saving of the company, if those people are not ready to fund the process.
Sir, are you an IP?
Yes, I am.
Sir, the interim finance is...
No, carry on, sir.
Please go ahead. Yeah.
No, I was talking about the funding of the CIRP cost and these related issues. Yeah, sir, please.
From the Ibc Fund.
Yeah, I think what Mr. Kathuria was trying to say very rightly, that if the people whose money is at stake are not willing to throw good money after bad, why should somebody else do it who has nothing at stake there? Absolutely right. Absolutely.
Why should CSR money be used for a project which even the people within the which FC find that there is no value, I'm not going to fund it. Why should my own money or corporate's money, that too a CSR money, which is for the social good at large, be used for corporate salvage? I don't really understand this.
You are right in a certain way. You are right, but what my thinking is that for a corporate, the creditors are going to fund the process most of the times. However, when we come down to the individual insolvency, then the issue starts off. When there are issues for there are no funds, there are no asset base of a individual or an MSME or a small business, then these funds may be utilized for reviving them or going through that insolvency process, and they're not very big costs.
Anyway, I think, Mr. Gupta, we can proceed because we have whatever views are there. We have taken.
Okay. So any more things, or should we wind up?
Sir, my answer is that suppose this company, when he going to the CIRP process, before that this company also given some share on the CSR fund before going to the CIRP. Any company in the future may go in CIRP, there is some fund problem or any business problem, but this company also some contribution in past. He also share some CSR fund. So what is the problem if the 500 crore or 1000 crore company make a kind of fund for the initiation of CIRP? So there is no any problem, because you see the example of Vodafone. So government 33%, they are not able to pay the AGR. They put the 33% of the share, or what will be the share amount money will be it will depend on the future. So 500 or 1000 crore is not a big deal for a government who are making the 100 or billions of rupees recovering from the insolvency bankruptcy through code, and every the kind of financial creditor getting their money. So I don't think so there is a very big deal of this fund, IBC fund, or we can just a drop of water can put in the IBC fund.
Chali, Anilji, this point has been noted by Nitin. It's almost time 1:11 p.m. So I think we had a very fruitful discussion, and Nitin would compile all the comments and suggestions made today and send it to IBBI before 5:30. Have you asked for an extension, Nitin?
Sir, I have not asked for an extension, but I'll be going through this recording again, noting each and every point, every suggestion that has been made, and I'll be able to send it by 5 o'clock.
Okay.
before the end of the day, sir.
Okay. Thank you. Thank you, everyone. Thank you for joining in.
Thank you very much. Thank you.
Thank you very much.
Hello.
Thank you. Sir.
Hello. Excuse me. Hello.
Thank you so much.
Thank you.
Thank you.
Thank you, everyone. Thank you, sir.
Thank you.